and under treaty law to respect the immunity of Sudan's representative to the League of Arab States, Summit. Under paragraph 2, Jordan had obligations under treaty law that were inconsistent with the surrender of Sudan's head of state to the court. In the light of these obligations, the court was required first to seek waiver of such immunity before proceeding with its request. To erase Article 98 from the statute, as regards Sudan, the pretrial chamber felt compelled to reach two legal findings, neither of which is sustainable. First, it concluded that Article 27.2, which is located in a completely different part of the statute, had a powerful effect on Article 98, essentially transforming it into an article that only speaks to non-party states. In our view, it's clear beyond doubt that Article 27.2 concerns only pleas of immunity by an accused person with respect to the court's own jurisdiction. This provision alone does not and cannot affect issues of immunities from foreign criminal jurisdiction. Secondly, the pretrial chamber concluded that Security Council Resolution 1593, or its paragraph 1 or paragraph 2 or some combination, we heard this morning of both, transformed Sudan from a non-party into, in essence, a party. These claims, we say, are unsustainable. The prosecution has put forward, or in a sense, piggybacked upon several alternative arguments that completely contradict each other. In our view, this shows the weakness of their position. They sought to row back a bit earlier this afternoon, emphasizing that they're relying on the reasoning of pretrial chamber 2. Mr. President, I want to return to the question of immunity and customary international law. Questions about this have been raised throughout the week, even though the matter, in our view, is not under appeal. But some very surprising propositions have been made. In essence, two arguments have been advanced. First, that immunity of heads of state from foreign criminal jurisdiction does not apply to foreign domestic proceedings for the arrest and surrender of a head of state sought by an international criminal court. Second, that there is an exception to the immunity of heads of state from foreign criminal jurisdiction when the arrest or surrender is sought by a court. These are similar but separate arguments, it seems to us. The latter advanced by Professor Kress. The prosecution strategy in advancing its novel absence of immunity theory seems to be to place a burden of proof, it seems to intend to place a burden of proof upon Jordan. They're saying there's no clear law, international law, giving immunity in these circumstances, so you have to prove it. An initial point is that it's not really appropriate to speak of a burden of proof in the context of identifying customary international law. The court knows the law, jure novat curia. They demand, however, that we show state practice and opinio juris, and they even do so even though pretrial chamber 2 said that such immunity exists and no one appealed that decision. I'd make a few brief points. Firstly, the immunity of heads of state from foreign criminal jurisdiction is a firmly established rule of customary international law. This immunity is absolute. International courts and tribunals have been unanimous in this regard. Likewise, the members of the International Law Commission in the topic immunity of state officials from foreign criminal jurisdiction were unanimous in finding no exception whatsoever to the immunity of a head of state. The Commission adopted draft Article 3 in 2013, entitled Persons Enjoying Immunity Ratione Personae, and it reads, heads of state, heads of government and ministers for foreign affairs enjoy immunity ratione personae from the existence of foreign criminal jurisdiction. And then Article 4 of the Commission's text provides that immunity ratione personae is absolute. There are no exceptions. This conclusion of the Commission was universally welcomed by states in the UN General Assembly. We heard that again this morning from the distinguished representative of the African Union. The prosecution's theory that immunity of heads of state does not apply to the present case is based on two false premises. First, that the judicial and other authorities of states parties are mere agents or organs or proxies of the court in executing arrest warrants. Second, that as a result they do not exercise their own criminal jurisdiction, but rather the court's enforcement jurisdiction. Mr. President, these arguments are entirely artificial. States parties are not mere instrumentalities of the court. They are independent, sovereign subjects of international law. States exercise their own criminal jurisdiction when they seek to arrest and surrender a person. It is irrelevant whether it is the court that requests the arrest and surrender or another state that requests extradition. Whatever the underlying reasons why a state exercises its criminal jurisdiction, it remains that state's own criminal jurisdiction. We would say that this is self-evident, but if the court requires further guidance, it can look at the statute, and particularly its Part 9, where, as Professor Murphy has already shown, several provisions make it clear that states cooperate with the court in accordance with their national law. They exercise their own jurisdiction. Mr. President, if we were to adopt this proxy argument, it would have, in our view, many unforeseen consequences. For example, at present, an accused may raise human rights complaints at the European Court of Human Rights in the parties to that convention. There have been cases in the United Kingdom where this has happened. In the case of surrender to the ICTY and I think to the Rwanda Tribunal. That could not be done if the English courts are regarded as organs of this court. It would also lead to all too foreseeable political consequences. Adoption of this theory would, I suggest, be a direct intrusion by this court into the most sensitive aspects of state sovereignty. Could the court order the national authorities to adopt a particular attitude in court cases, for example? It would be an intrusion into domestic criminal justice systems. It would, I think, give credence to those who speak out against the International Criminal Court as an infringement of sovereignty. Just a word about the notion that was thrown out this morning about dédoublement fonctionnel. I don't find that particularly attractive, and I'm not sure what its effect would be on immunity. Would the head of state be perhaps half immune in such circumstances? Mr. President, the prosecution rightly noted that one argument that could be advanced against what Professor O'Keefe referred to as its patent fiction is that it would be all too easy for states to set up an international criminal court and so avoid their international obligations. Such an outcome would obviously be unacceptable, yet it would be perfectly possible if the prosecution's thesis were to prevail. This court, Professor Kress, has sought to distinguish between what he termed a possible Franco-German court and this court, which he claims has jus poniendi of the international community. I agree with what Mr. O'Keefe said this morning about that. If you look at the states who are parties to this statute, to the Rome Statute, it's hard to see how they can represent the international community. I won't list names, he did that this morning. Mr. Chairman, Mr. President, if you excuse me, I'd like to turn to Professor Kress's deductive approach, which we heard again today. In our view, his approach has absolutely no support in the practice of states or the case law of the International Court of Justice as an approach to the identification of customary international law. I've already explained, he referred to paragraph 61 of the arrest warrant case. We've already explained that that in no way says what Professor Kress asserts. It does not say that there is a customary international law exception to the immunity of heads of state, and he's pointed to no other state practice or case law that supports his position. I would respectfully refer the Chamber to the International Law Commission's conclusions and commentaries on the identification of customary international law, which were adopted on second and final reading in August. They can be found in the annual report of its session in 2018. And the Commission makes it clear that in the wording of its conclusion 2, to determine the existence and content of a rule of customary international law, it is necessary to ascertain whether there is a general practice that is accepted as law opinio juris. And with all due respect to my very good friend, Professor Kress, his approach might better be called the invention of customary international law, not its identification. Mr. President, Professor Kress raised again yesterday the work of the International Law Commission on the immunity of state officials. As we've already explained in response to the prosecution, a proposal in 2018 for a saving clause in Article 7 of that project was made by the Special Rapporteur. That proposal was not included in the text adopted by the Commission in 2017. It appears nowhere, neither with respect to immunity ratione personae, nor with respect to immunity ratione materiae. Professor Kress asked for documentary references, and I'd refer him to just 3. There's paragraph 248 of the rapporteur's 5th report. There's the statement by the chairperson of the drafting committee in 2017, and the 2017 report of the Commission to the General Assembly. Yesterday, Professor Kress referred to paragraph 43 of the Special Rapporteur's 6th report. Debate on that report has just begun and will continue next year. But in paragraph 43, the Special Rapporteur simply recalls that she expects the Commission to consider the saving clause again in the future. Mr. President, nothing whatsoever can be deduced for the state of existing law from the fact that a proposal has been made by an ILC Special Rapporteur which may be considered in the future. That says nothing whatsoever about the Commission's views on the matter. Mr. President, I was going to say a little bit about the interpretation of Resolution 1593, but I think, in fact, nothing new was said this morning, and we have set out our position on that in some detail throughout the week. Perhaps just a word about the debate we've had on the necessary implications of Security Council resolutions. As I've already said, and as the representative of the African Union said this morning, drawing implications from binding council decisions under Chapter 7 is a very dangerous route to go down. Does a resolution also, by implication, authorize a state to invade another state so as to bring an indicted person to the court's custody? Does it authorize a state to enter foreign embassies in its capital to obtain evidence? An interpretation of the Security Council referrals which had such results would certainly make referrals highly unlikely in the future. At the end of the day, Mr. President, it seems to us that the prosecution's arguments boil down to this. The immunity of Sudan's head of state must be lifted because otherwise he could not be brought before this court. This is simply not the case, as Professor Murphy has explained again this morning. Indeed, experience shows that heads of state have ultimately appeared before international criminal courts in various ways. But the prosecution's basic arguments seem to us to be consistent with their apparent view that it really does not matter what line of legal argument one uses, provided that you come to the right result. With very great respect, Mr. President, members of the Chamber, this is a court of law. As such, it has to reach decisions on sound legal grounds. The Chamber cannot be swayed by policy considerations. Its task is to apply the law to the facts, not to reach a particular conclusion. Mr. President, I thank you for your attention, and with your permission, Professor Murphy will now continue our final submissions.
Thank you, Mr. President. As a part of its final submissions, Jordan wishes to revisit and stress a few points relating to its third ground of appeal, which, as you know, concerns the propriety of the referral of Jordan to the Security Council and to the Assembly of States parties. My first point, as we outlined in our written and oral submissions, Jordan strongly believes that the appeals chamber should set aside the decision on referral. In our view, the pretrial chamber's decision arises from manifest errors of law and fact and amounts to an abuse of discretion. And we appreciate very much Professor Robinson's views in this regard, where he agreed that such manifest errors of fact and law do exist. My second point, the circumstances surrounding the interactions of Jordan and the court at the time of the visit are essentially uncontested. After the court's initial communication, Jordan sent 2 different notes verbal to the court in advance of the visit. At the time, the prosecution recognized that Jordan was seeking consultations. The prosecution urged the pretrial chamber to initiate those consultations, and yet the pretrial chamber did nothing. Neither the prosecution nor the pretrial chamber at that time complained that Jordan was acting improperly or for purposes of delay. Rather, we think the facts are clear that Jordan took the matter seriously and worked to determine both the facts of a possible visit and the legal situation that it was facing. Again, as Professor Robinson suggests, Jordan was not being defiant. Now, the prosecution this morning or this early afternoon said that there's an issue here about the timing of Jordan's reaction to the communication from the registry, that it was so close to the time of the visit. In our view, that is not sustainable. We did approach the court several days before the visit. The prosecution urged the pretrial chamber to act. Nothing happened. Moreover, and this is perhaps the more important point, timing was not an issue according to the pretrial chamber below. In the decisions with respect to referral, they say nothing about, Jordan, you came to us too late, Jordan, you didn't give us enough time. It's not that at all. It's a claim that Jordan was taking a firm position that was unchangeable in some sense, which we think simply is not sustainable on the record and certainly was not the position that the prosecution itself was taking at the time. The prosecution also said that this is a situation where the court has to lead these consultations. We agree with that, but where was the leadership? We approached the pretrial chamber days before the visit. Prosecution urged them to act, and nothing happened. To the extent that there was a lack of leadership, we submit that it came from the pretrial chamber and is not something that can be imposed upon Jordan as some sort of fault with respect to our consultations. My third point, the pretrial chamber does have discretion as to whether or not to refer a state to the ASP or the Security Council, but that discretion is clearly not unlimited. The appeals chamber has made it quite clear that it will set aside a decision to refer in circumstances where there's an erroneous interpretation of the law, a manifest or patently incorrect conclusion of fact, or where there is an abuse of discretion. My fourth point, the pretrial chamber's explanation for referring Jordan consists of just 4 sentences. And those are found at paragraphs 53 and 54 of the December 2017 decision. 4 sentences. And in those 4 sentences, 2 very brief reasons. The fifth point, then, is to look at that first reason for the referral, which was essentially that Jordan failed to comply with the court's request. The claim being made by the pretrial chamber is that we took a clear position about the ability to do the arrest and that we did not expect anything further from the court. That's essentially a quote. We think that clearly is based on an incorrect conclusion of fact. Jordan was seeking consultations in good faith at the time in question. We were not simply refusing to comply. Moreover, that reason is based on an erroneous interpretation of the law to the extent that we are being referred simply by virtue of the fact that we were in noncompliance. That is inconsistent with the appeals chamber's view that noncompliance should not result in an automatic referral. Rather, the totality of the circumstances of the case must be considered, including whether engaging external actors, such as the council, such as the ASP, would be an effective way of obtaining cooperation. No such discussion of that kind appears anywhere in the pretrial chamber's decision. Instead, the chamber simply decided to refer Jordan. My sixth point, I have 10 total in case it's of interest. Sixth point, Article 97 of the Rome Statute contains none of the requirements for consultation that the prosecution apparently now finds lacking in Jordan's effort to consult. When you look at Article 97, it simply provides for a state party to consult without delay when the party identifies problems which may impede the execution of the request, and we submit that Jordan did that. Now, we think that the discussion this week, including today, makes it quite clear that everyone thinks the procedures regarding consultation need to be improved. And I think some of the questions from the appeals chamber are along the lines of how might we do this better. Indeed, we would agree with that. And we think that the steps taken 9 months after the visit to Jordan at the ASP to adopt the resolution that it adopted was an effort to deal with improving these procedures. But even on those procedures, it's quite clear that the expectation is when the state seeks a consultation, the court, whether it's the pretrial chamber or the prosecution, should be responding without delay. And that simply did not happen in this case. Consequently, we don't think Jordan can be held at fault with respect to the manner in which the consultation proceeded. My seventh point. The second reason for the referral, according to the pre-trial chamber, was that at the time of President al-Bashir's visit to Jordan, the chamber had already expressed in unequivocal terms that South Africa had, in analogous circumstances, the obligation to arrest President al-Bashir. This reason, too, is based on a manifestly erroneous error of fact, given that the proceedings regarding the legality of South Africa's actions were still ongoing as of March 2017. It's only in July 2017, 4 months after the visit to Jordan, that the pretrial chamber says, should there have existed any doubt in this regard, it has now been unequivocally established, both domestically and by this court, that South Africa must arrest Omar al-Bashir and surrender him to the court. That's when it's unequivocally established. Therefore, it couldn't be the case that 4 months earlier that was already established. Moreover, regardless of how you think about what was going on with respect to South Africa, there's no unequivocal expression directed to Jordan in this regard. For example, the registry's communication that originally comes into Jordan prior to the visit says nothing about South Africa's proceedings. The prosecution this morning refers to meetings at the Security Council that Jordan has attended that somehow puts Jordan on notice. But that was never a part of the pretrial chamber's claim as to unequivocal expression of the South Africa situation to Jordan. Instead, their view is we should be aware of transcripts of a meeting between South Africa and the court, and that somehow that's the way in which we became aware. The reality is, Mr. President, the reality is that as of March 2017, there are serious doubts, both within the court and outside the court, as to the principal legal theories that have been advanced by the pretrial chambers, theories that we have again discussed at some length this week. If those arguments were wrong, and I think in my presentation of a day ago I indicated that the prevailing theory as of March 2017 eventually is determined to be wrong by the pretrial chamber below. If those arguments were wrong, then it's entirely plausible for Jordan to form a view in good faith in March 2017 that there was still immunity for President al-Bashir. And we submit that the pretrial chamber below simply doesn't take account of that. The pretrial chamber ultimately did conclude in July 2017 by majority, not by the entire pretrial chamber, that the prevailing legal argument at the time of the visit was wrong. It went on to decide on an entirely new legal theory that involves a complicated scenario of Articles 27 and 98 and, if I understand correctly, an Article 86 anti-loophole provision of some sort. All sorts of bells and whistles come up in July of 2017. Fine. None of that is known as of the time that President al-Bashir visits to Jordan. Indeed, in your order, Mr. President, your order of this past summer, May 2018, you said the present appeal presents novel and complex issues, and that this is presumably why we needed to go forward with this particular process involving amicus and so on. The second reason for the referral was also based on an erroneous interpretation of the law, which is that the pretrial chamber assumed that the law as applied to one set of facts relating to South Africa automatically applies in the same way to a different set of facts involving a different state party. The prosecution yesterday at least seemed to concede that the circumstances of two different cases of referral should be dealt with separately, yet that's exactly what the pretrial chamber failed to do. My eighth point is that in addition to the manifest errors of fact and law, the appeals chamber referral constituted an abuse of discretion. In the first instance, it was an abuse of discretion given the chamber's differential treatment as between South Africa and Jordan. We explained this in our appeals brief. I won't go into it in any depth, but when you look at the discussion in the South Africa context, which then led to a non-referral, and you compare it to Jordan's situation, it's clear that the reason for us being referred cannot be sustained if one takes seriously that earlier argumentation. For example, if it's relevant that there had been all of these different meetings at the Security Council and Assembly of States parties that didn't result in anything, and that's a reason not to refer South Africa, presumably a similar reason should have been employed or at least discussed in the context of Jordan, and that does not happen. My ninth point, the pretrial chamber's decision to refer was also an abuse of discretion because it failed to give weight to any relevant considerations that we think should have been brought into play. Jordan's efforts at consultations with the court. The factual record simply isn't being discussed by the pretrial chamber. The failure to think about, at least, the fact that there's multiple legal theories floating around that might have had an effect on the way Jordan's approaching the matter. Nothing in the pretrial chamber's considerations with respect to that. The OTP says that it's relevant that South Africa had national laws and national court possibilities with respect to implementation of the request from the court. Well, of course, in that instance, it didn't prevent the arrest or it didn't result in the arrest or surrender, but the more important point would be no effort, no interest in querying Jordan about, well, what does your national law say on this? Are your courts open for availability? Maybe the pretrial chamber would like the answers, maybe not, but it didn't even express any interest in that matter. And then perhaps most importantly, no discussion of how a referral to the ASP or the Security Council would help in some way in bringing about Jordanian compliance. That simply is nowhere to be found in the pretrial chamber's discussion. My 10th and final point is that it is not appropriate to use Jordan for some broader policy purposes relating to sending a message to states parties or even worse, punishing Jordan. Indeed, we were struck, Mr. President, that yesterday and this morning, all of the participants in this hearing, except the prosecution, and I think Professor Latanzi, did not call for a referral, the referral to be upheld. In other words, most of the participants in this proceeding seem to think that it would be appropriate to set aside the referral. If ultimately the objective is to secure cooperation from states parties, the most effective way for doing that in this proceeding would not be to uphold the referral. Rather, it would be for the appeals chamber simply to reach a soundly based decision on any unresolved legal issues that you see before you as a means of guiding states parties in the years to come. We think this point was made aptly by Professor Robinson and his colleagues in their observations, and we note and welcome Professor Kress's comments this morning as well, that the sufficient and much needed remedy may be simply clarification of the law. In conclusion, Mr. President, we do believe that you should uphold our third ground of appeal. With your permission, Ambassador Hammoud will complete our final submissions.
Mr. President.
You have 17 minutes.
Yes.
Just so you know.
Yes. Thank you. Well, I think I'll be less than that. Thank you, Mr. President. The hearing this week has shown that there are quite divergent views on the state of law as regards the issues on appeal, which my colleagues, Sir Michael and Professor Murphy, have just elaborated upon. Jordan fully understands the overall context of the hearing and the various legal interests involved. However, and we have already stressed this many times, we should not forget that this is an appeal of the decision of the pre-trial chamber 2. That decision, based on certain findings of law and fact, concluded that Jordan was in violation of its obligations under the Rome Statute and that it should be referred to the Assembly of State Parties and to the Security Council. The scope of this appeal is the 3 grounds that Jordan put forward to the appeals chamber and that were approved for appeal. Nothing more, and nothing less. We respectfully ask that the chamber take into account the arguments that Jordan, the Arab League, the African Union, and some of the Amici Curiae have made, reach a decision upholding all 3 grounds of our appeal. Jordan has been a party to the Rome Statute since 2002. And as I mentioned earlier during the hearing, Jordan played a very important role in the negotiation of the Rome Statute and the establishment of the court. Indeed, we have always been a firm believer in the rule of international law, which protects the rights of all states and their peoples, without regard to their power or might. This is a key reason why Jordan decided to ratify the Rome Statute. Fighting impunity is not only a humanitarian objective, it is also a tool for the preservation of international peace and security and the deterrence against the threat and use of force. This may be a rhetoric for some and a noble cause for others, but it is also a necessary element for the maintenance of international world order. Being a firm supporter of the court and committed to the fight against impunity, Jordan finds itself in a peculiar and a difficult position where it has to defend itself against accusations of breaching its international law obligations that trigger its international responsibility. Why has this come to pass? It must be understood that international law is not confined to the objective of fighting impunity. The maintenance of peace through inter alia friendly and orderly relations between states is another key objective. We cannot look at the international law from one angle and seek to protect a single cause or legal interest at the expense of others. Rather, we must recognize that different rules are designed to address different objectives. And as the International Law Commission said in its study on fragmentation, when several norms bear on a single issue, they should be, to the extent possible, be interpreted so as to give rise to a single set of compatible obligations. We believe that this goal of harmonious interpretation is embedded in various parts of the Rome Statute, including in Article 98. Such a goal seeks to reconcile obligations that arise from different sources, in recognition that states wish to achieve multiple objectives. Helping to maintain international peace and security is a goal that I am sure this esteemed chamber is seeking to achieve, as well as we, Jordan, sincerely hope that our legal position in this appeal will be viewed in such context. It is against this background that I would like to note that Jordan has been a member of the Arab League since its creation, even before the United Nations was established. Jordan has signed and ratified the Pact of the League in 1945 and has been an active member in promoting the goals and purposes of the League, both in promoting regional peace and security and advancing political, social, economic, and cultural integration between Arab countries. Jordan is also a party to the relevant Arab League conventions, including the much talked about this week, the 1953 Convention on the Privileges on Immunities of the Arab League. We take these obligations very seriously indeed. They are of critical importance to us as a state and as a nation. With respect to the 1953 Convention, maintaining the privileges and immunities of the League representatives as at its many meetings, including at the annual summits, is of the most importance for the League. Such protections allow the League to properly carry out its functions, as Ambassador Abdulaziz of the League made clear this week. Jordan has important international obligations arising from the League's legal instruments, all of which predate Jordan's ratification of the Rome Statute. Being a member of the League, Jordan must at times host League summits and must assume presidency of the summit during that year. Hosting the summit on a rotational basis has been approved by the League's Council by concluding a protocol in the year 2000 to the Pact of the Arab League. In that context, one of Jordan's crucial obligations is to receive the heads of state and other representatives of member states of the League, pursuant to Article 1 of the said protocol. Another obligation is to provide the head of state and any other representative of that state with diplomatic privileges and immunities under Article 14 of the Pact, and immunity from its criminal jurisdiction and inviolability from arrest under Article 11 of the 1953 Convention. Now, Mr. President, suggestions were made this week that the head of state need not be present at the summit. Yet any Arab League head of state who wishes to attend the summit is entitled to do so under the Pact, the Arab League Pact, and its protocol, as I described above. If the head of state attends, then the host state has to fulfill its obligations under the Pact and under the 1953 Convention, including the provision of the necessary immunities from the host country's criminal jurisdiction. Mr. President, this background should be considered carefully by the Chamber when it considers the grounds of appeal presented by Jordan. Had Jordan arrested President al-Bashir, not only would Jordan have violated his immunity persona ratione as sitting head of state, but also Jordan's obligations under the Arab League Pact and the 1951 Convention, whose obligations would prevail, as you know, in accordance with Article 30, Paragraph 4 of the Vienna Convention of the Law of Treaties. This is why we sought consultations from the court under Article 97 of the Rome Statute in March 2018, prior to the visit. And Mr. Murphy has elaborated on this and on the fact that to this day, the pretrial chamber 2 hasn't responded. We identified legal impediments, and we indicated that we did not perceive any way around these impediments. We are now told, Mr. President, that our obligations of cooperation under the Rome Statute are crystal clear, that it is obvious to all that Article 27, Paragraph 2 modifies Article 98, and that the Security Council Resolution 1593 obviously transforms Sudan into a quasi-state party, with obligations, obviously, but without any rights. This is how we're supposed to understand it. And we are told that if all that is not true, then other things must obviously be true, such as that the Council resolution waives immunity ratione personae from Jordan's criminal jurisdiction, or that Jordan or Sudan or both have abused their rights under international law, or that Jordan, and I think one suggestion was made, has violated jus cogens. Now, the prosecutor and some amici want you to believe that this was all obvious. But I assure you that none of this was obvious to Jordan in March 2017. And quite frankly, it remains obscure and contentious issue today. Mr. President, Jordan has been a member of the United Nations since 1955 and has been on the Security Council 3 times. The last was in 2014-15, a matter mentioned yesterday and today by OTP, and I didn't want to respond to this, but just like to add, this is where we witnessed the frustration by the Office of the Prosecutor from the process before the Security Council, in the same manner that we witnessed that no Security Council member, no member, during the 4 meetings that we were present in the 2 years when they reviewed the situation in Darfur, and the referral in Darfur, even hinting that the President al-Bashir lacked immunity ratione persone from the criminal jurisdiction of the Rome Statute parties. And no action, obviously, was taken by the Council. Mr. President, since its admission to the United Nations, Jordan has been actively engaged with advancing the principles and purposes of the UN Charter, whether through its contribution to peacekeeping operations, through its engagement with human rights bodies, and membership of the Human Rights Council, by advancing the rule of international law through nominations to the International Law Commission and the International Court of Justice, or by taking leading role in the humanitarian issues of the United Nations. Indeed, Jordan has been playing crucial role on behalf of the international community in, inter alia, hosting more than 1.3 million Syrian refugees who are not able to return to their country due to the armed conflict and humanitarian disaster in Syria since 2001. We did the same when Iraqis took refuge in Jordan as a result of the Second Gulf War. Hundreds of thousands came to Jordan, and we are the host of the largest number of Palestinian refugees in the world. So obviously we play a big humanitarian role on behalf of the international community.
You have 5 more minutes.
It's 2 minutes. Jordan has been a voice of moderation and peace, not only in the Middle East, but throughout the world. A country that respects the rule of law, human rights, and humanitarian obligations. Therefore, we find it disturbing that we are accused of violating the rule of international law and our obligations under the Rome Statute, that we are contributing to impunity, and that we should be set up as an example to the world to be referred to the Security Council and the Assembly of State Parties. And not least, that we are treated here as, quote unquote, a party to a proceeding in the ICC, where we have to respond to the prosecuting arguments, oscillating arguments, and connect the dot propositions. We see this not only as unfair, but an abuse of the process of the Rome Statute, as troubling effort to find Jordan culpable by whatever means are possible, pursuant to the apparent new motto of the prosecution that all roads must lead to Rome. Mr. President, Jordan has full respect to the court. We have appeared before you this week in good faith to explain the arguments as to the fact and law that we believe are correct and persuasive. May I stress that you are a court of law, as Sir Michael has said, who should be guided by the principles of international law, not by policy or advocacy. The courts, and we are sure that you will be able to uphold the rule of law. This is why it is our hope that you will uphold all 3 grounds of our appeal. And in that regard, I wish to confirm Jordan's request that appear at paragraph 115 of our appeals brief. I now wish to close by placing on the record my government's thanks to the staff of the court, including the timekeepers, interpreters, escort personnel, and security staff for all their hard work this week. And of course, I wish to thank you, Mr. President, and other members of the appeals chamber for the respect, courtesy, and attention that you have accorded to Jordan with respect to our appeal. And finally, I thank the amici for making the effort to contribute to this hearing. Thank you, Mr. President.
Thank you very much, Ambassador. We have spent the past 5 days looking at questions presented in this appeal. We have looked at them from many angles for perspective. The exercise has absorbed the minds of lawyers from all corners of the world, a cross-section of whom are gathered or have been gathered in this courtroom for the past 5 days, from Australia to Canada and the United States and all other regions in between. And when I say lawyers, that includes those sitting up here on the bench. Every minute of it has been well worth it. The views have converged in some respects, but they have remained mostly diverged on many of the capital issues that trouble the appeal. But that is in the nature of the work of the legal profession. It only underscores the naivete of any expectation of a perfect answer to a legal question, one that is expected to be immune to any criticism by the brightest legal minds. There is no such thing. That phenomenon was given voice many years ago by Lord Macmillan in 1931 publication of his entitled Law and Other Things, where he said, quote, "In almost every case except the very plainest, it will be possible for a judge to rule on either side with sufficient legal justification," unquote. We do not pretend to any ambition to prove Lord Macmillan wrong, but we remain guided by the applicable law, both the Rome Statute and international law, in their text and spirit, in their context, and in light of their object and purpose. We have been immensely assisted by the views you have shared with us in that regard, but beyond the assistance, it has been a pure joy listening to all of you debate these questions in the past 5 days. You are amongst the leading legal minds on the questions presented, and we have not missed anyone else assisting us with these questions. Thank you very much for assisting us and for being here, and we wish you a safe journey as you travel back home. We thank all the court staff, the interpreters and the court reporters and the technicians and the security for assisting to make this hearing possible. The hearing is adjourned. Thank you.
All rise.